trending largely in the law today is the issue of sanctions against the agency, and particularly what a federal employee should be doing when he or she receives the report of investigation. Now, as we all know, in a discrimination or retaliation case, a federal employee at some point will file a formal complaint, usually, and the agency will have 180 days to compile a report of investigation, or otherwise known as an ROI. And the agency will hire an outside lawyer, usually some investigation firm or a firm that has investigative services, and they will assign usually one investigator to come to the agency, interview not only the employee, but the others who are connected to the case, the employee's supervisor, co-workers, etc. At the end of that process, there will be a book, usually around 200 to 300 pages per issue, which will have an investigative section. There'll be a summary of what happened in the ROI, and there'll be a group of affidavits, there'll be some documentation, and at the end of the ROI, very important, the investigator may have some notes to the file about how this person handled the investigation. Now, the statutes and the law require what's called an appropriate investigation. Used to be that it was needed to have a complete investigation, but regulations changed back in 1999, and now it's just an appropriate investigation. And that is defined as one that allows a reasonable fact finder to draw conclusions as to whether discrimination occurred. So when you get your ROI, you should be looking through the ROI to determine first, is there enough information for a reasonable fact finder to determine whether there was discrimination or not. Now, what does that mean? Well, let me give you a few examples on both sides of the coin. Let us say there is a case in which there were 12 or 14 promotions that a federal employee was supposed to get. And a federal employee applied for all 14 of these, didn't get any. The ROI comes back, and the ROI fails to identify who the selecting officials were or the reasons that the agency did not promote the employee. That is a classic example of an ROI that a reasonable fact finder cannot draw any conclusion as to whether discrimination occurred or not. After all, we don't even know who made the decision. We don't know why the decision was made not to promote the employee. That one is worthy of sanction. Here's another one. Employee is at a bar. Employee brings up some other employee's discrimination case. A manager overhears it. The employee has a couple of drinks, and the employee is shooting his mouth off about how he's so happy that this other employee sued, how the agency has a ton of problems in the area of discrimination, so on and so forth. The manager hears all this. 2 days later, the manager disciplines the loudmouth employee making these comments. Okay? That is a classic case of retaliation. Absolutely. What happens is the EEO investigator is told, usually I help my client direct these investigations, and that really does pay off because you can force these investigators to ask what they need to. And in this case, this is what I'm talking about here, actually was a case that did happen that the agency agreed to go to mediation on. And the investigator had to ask, as part of the investigation, who was at this bar, what did they hear, and why they took the actions against the employee. If they did not do that, if either the investigator didn't ask the questions or the agency witnesses didn't answer them, that is called not providing enough information for a fact finder to draw conclusions as to whether discrimination occurred. Now I'll give you some on the other side. Woman, she is denied telework, and she says, some other employee who has the same job as I do, he was not denied telework. He's of a different race than me. That's discrimination. The investigator never interviews the comparator, and the management official contends that the comparator was on a medical condition and that his case was different. The employee contends, no, he didn't have a medical condition and you didn't probe that issue enough. Okay? That is not an example of not having information as to whether discrimination occurred or not. There were the bare bones investigation that was done, and that's really all that has to happen here. It doesn't have to be complete. The agency gave an answer. You may not like the answer. You have discovery in your report of investigation. After that's done, you're able to go ahead and do discovery. Usually an administrative law judge will give you 90 to 120 days to do that. And you can find out the details of why this case was treated differently than the employee who was denied telework. So, very important, the first thing you have to do is draw that distinction. Was there enough information? And if there wasn't, what you need to do, what I do when I get these from my clients, is I immediately make deficiency motions. And I tell the court that this case should not go on. The defendant here, the agency, should lose right away because this is deficient. And it's deficient in key areas. And I point that out to the court. And sometimes I will compel or force settlements right then and there. Other times, I may move for summary judgment. And I will say, look, the agency cannot defend the case. The reason they can't defend the case is they're not able to produce basic information about the case. The point of discovery, and this is a question that I get all the time, why then do we have discovery? Why isn't the ROI enough? And the answer to that is the courts allow employees to continue the investigation, and discovery is part of the investigative process. The hearing really is supposed to be also. But the court allows the litigants, particularly the complainant, to dig into the answers of the government and to perhaps change the mind of the fact finder, or to show the fact finder that what appears in the ROI is not so. But the point of discovery should not be to produce an ROI. I mean, it shouldn't be and I've argued this very point to a number of administrative law judges, it should not be the employee, the person who brought the discrimination case. It should not be that employee's financial responsibility to complete the ROI for the agency. The agency has a responsibility to put the basic information, enough information in there to draw conclusions as to whether discrimination occurred or not. For those of you listening to this podcast who may have litigated a case pro se, without a lawyer, you may have noticed that at one of your conferences with an administrative law judge, the administrative law judge, before even ruling on the case, has weighed in on the case merits. And the administrative law judge has probably said something to you along the lines of, I've looked at this case. It seems kind of weak. There are a bunch of problems. I recommend that you take some non-monetary settlement or something small because you're going to lose. And you may ask yourself, well, how can an administrative law judge do that? Isn't that person supposed to be open and fair-minded and wait till all the facts are in to render an opinion? And the answer is no. Again, the administrative law judge is doing what he or she is supposed to be doing. Reviewing the report of investigation and making a conclusion as to whether discrimination occurred or not. Now, he or she is giving you an opportunity in discovery to change his or her mind. But that is perfectly appropriate behavior by an administrative law judge. I think one of the things that's really important that comes across in these cases that I have handled in terms of deficient ROIs are the memos at the end of the report of investigation by the EEO investigator. Okay, I'll read you part of one. It says, a request for documentation of EEO complaint X number was sent by email to this person on December 22nd, 2015. No documentation was received. A second request was sent January 22nd, 2016. There were partial set of documents received in February, but not enough. A reply was made, so on and so forth. The letter goes on where the investigator goes through all of the steps that he or she took to secure the documentation in the ROI and all the steps that were not acted upon by the agency. Very, very important. And in fact, I could call the investigator at the hearing to testify as to these notes. In fact, the notes are already into evidence. Everything in an administrative law hearing that's in an ROI and in Title VII cases automatically into evidence. So it would seem very strange that the notes, which are hearsay, would be evidence, but live testimony from the EEO investigator would not be allowed. That would seem nuts. So the EEO investigator would testify to each step along the way. And you have to really play that up in your litigation. You have to demand that in discovery. You have to ask for all of the communications from the EEO investigator to the agency and vice versa. And you have to show the judge that even if they were to produce these records right now, let's take the case of the 14 promotions, and they had, in theory, an explanation from every single selecting official why they didn't pick your guy. That had nothing to do with discrimination. Doesn't matter. They should still lose the case because of the fact they didn't cooperate with the EEO investigator. And those records are tainted. Very, very important, because if you allow the agency and the administrative law judges to run these cases in their usual way, which is the agency not really providing that much during the report of investigation, the onus on the employee to really vigorously litigate the deficiencies without these deficiency motions or without a summary judgment motion. The chances of winning are not nearly as great as if you had gone to an attorney right away, as soon as you got the ROI. Even before that, I would do it. I recommend that to my clients all the time, because I write emails specifically to the investigators. Questions like, Miss Investigator, I'm looking through your affidavits that you've prepared, or your interrogatory questions that you've prepared for this agency witness. You're specifically not asking the following. What were you told about the conversation at the restaurant involving my client? I need the answer to that question. Otherwise, this is a deficient report of investigation. I'm going to make a motion. And if a judge determines it's deficient, guess what? This agency is not going to use you again as an EEO investigator. And you're just handing me the case. Very, very important to do that.